I am Hamish. This is Stan. This is Civil Banter. We're two lawyers at Nelligan Law, helping people through injuries, insurance fights, and navigating life's legal curveballs.
How's it going, Hamish?
Good. It has been quite the hiatus. I suppose we could blame tariffs, perhaps, but that's not the real answer as to why we've been gone so long.
No, we'll leave that as a mystery for now, perhaps to be unveiled in a future episode, but there is an explanation for our lengthy absence.
There is, and um, this is festive themed. I think the colors are looking good. We've got some red around the desk and the TV, and some green around the shelves. And the reason we're going festive is we're recording at the crunch time in December.
That's it, which leads, given our large absence, everybody, I'm sure the legion of fans, they're wanting updates, but the most important update, it's reaching way back to one of our early, if not our first episode. They want to know, is the Home Alone house that you got as a wedding gift, is that completed and ready for the holiday season?
Unfortunately, not.
Oh, that's tough.
If you've been following the housing industry, we're in a bit of a downturn right now. So
You need some government funding.
yeah, the Home Alone Lego house has not been completed. I am slacking. I have a very minimal number of days left at this time, and I'm unfortunately going to have to prioritize a trial that is being heard at the detriment of completing Kevin McAllister's Lego Home Alone house.
Look at that. Delays in the construction industry, at home, in the workplace, all over the place.
Okay, so moving on to our next segment, we're going into Two Truths and a Lawyer. Now, in this segment, I've picked a bio of one of our esteemed Nelgan Law colleagues, and I will be saying two truths and a lie from their bio. This one's extremely hard. I actually forgot at first glance which one was the lie. So, Jacob Harper. Jacob is a lawyer in our business law group, an estates law group. He's been here, it's over a year now. And he's already started to get sick of us asking him corporate questions how to locate different corporate defendants and have I named this guy properly, and what would happen in this situation. And it comes up on files constantly when you're trying to litigate and then you're like, wait, have I named the correct entity? And that's when I go and knock on Jacob's door, and he's very accommodating.
Always has answers.
Always has answers, and estate stuff too.
Yeah.
Really helpful to have a solicitor side estates and trust lawyer in the firm. Comes up constantly. So, Jacob's bio. 1. Jacob has worked at a vineyard in Niagara-on-the-Lake.
Definitely from that area. So certainly possible.
The second statement is going to be Jacob can speak a little bit of German.
I believe he cheers for the German national team when Canada's not involved in worldwide football or soccer or whatever it is in German. So that's possible as well.
How about this one? How about Jacob was a mooting finalist in law school?
I mean, that sounds quite possible as well. I know that he went to school in England and that there's a good mooting culture over there. So certainly possible. I don't want to drag this on forever. So I'm going to, because they all sound absolutely plausible. I
Mhm.
don't know if this is just cruel, frankly. I'm going to guess A, that even though he's from that part of Ontario, there's a lot of wineries that he's never actually worked at one of them.
Well done, yeah. Jacob has not, well, to my knowledge, maybe he
Maybe he
has.
has.
Maybe I need to start doing more background research, but according to at least Jacob Harper's bio, he has not worked at a vineyard in Niagara-on-the-Lake.
Doesn't
But
seem resume worthy then, maybe to him if he has done it.
yeah, if he's done it, yeah, I guess absence of evidence is not evidence of absence. But in his spare time, Jacob does enjoy racing sailboats. And in 2023, he placed second at the Shark World Championships in Niagara-on-the-Lake with his younger brothers.
He is an excellent sailor.
Yeah.
Yeah.
Okay.
Takes us to our topic of this week's episode, which is waivers. Hamish, what's a waiver?
A waiver is something we've likely all signed.
I think so. I've signed many of them.
We may or may not have read them before we signed.
Yeah, maybe.
And essentially, it's waiving.
Which
Why
means
waiving? Oh, this is where it starts. This is where the complexity starts. It's no hand waving. It is.
AI,
It's real. It is.
WAI,
It is committing.
not WAV.
Signing a waiver, and a waiver is basically a way to prevent someone from suing you in the event of, in this situation, personal injury when they're involved in an activity. And it's where the person signing is assuming the risk of doing whatever the activity is, subject to specifically what's outlined in the waiver and what can be implied from the waiver. So, generally speaking, an easy example is if you're doing something like skydiving. Now, how many operators are going to want to set up a small business, buy a Cessna, get parachute qualified, and then start, taking people from the general public up to do some tandem skydives if uh, something went wrong and then they knew that they could get sued and there would be no recognition that the person engaged in the pursuit had assumed the risk. In
Yeah,
this case, it's making it explicit. When there's a waiver, it's explicitly assuming the risk, signing, and basically signing away your right to be able to pursue someone in a lawsuit if something goes wrong.
that's right. If you're engaging in a inherently risky activity, go-karting, skydiving, axe throwing, God knows what, anything like that, then you may be asked to sign a waiver in advance of your participation in that activity, recognizing that it's riskier than going to the grocery store and that kind of thing. And so, what we're looking at this episode is if I am asked to sign a waiver and I do sign that waiver, is it valid? Can it be a reason or the reason why I would be prohibited from commencing a lawsuit in respect of injuries I've sustained while engaging in that inherently risky activity?
Right. Right. And as we said, this it comes up a lot, and the starting point as to when a waiver will and will not be upheld is the starting point is a waiver is a contract. And if you're signing a contract saying essentially, I will not hold you responsible if I get injured doing this thing, then the default starting position is, yeah, you signed, you're an adult unless you had capacity issues or you were not legally capable of signing that, then you're going to be bound to that contract as a starting point, which leads us into um, our example, which is a recent Ottawa decision from 2024, Bernier and City of Ottawa and a whole host of other defendants.
That's it. Yeah, this decision is a Justice Williams decision, really excellently written. I don't think excellently is a word, but it's a really well written just decision that I found easy to follow, easy to read, and you come away with a really good understanding of waivers, how they operate, and how in this particular case it operated to skipping to the end, prevent this plaintiff from recovering personal injury damages.
Yeah, so in this case, to cut the long story short, um, a waiver was upheld. And during this summary judgment motion, which is essentially a way to cut off a claim before it goes all the way through a trial on the basis that a defendant said, hey, I have a defense. This defense can cut short the whole proceeding. We don't need to go to a trial. So the defendants brought a motion for summary judgment saying the motion is or the waiver is a yes no question, like is it going to be upheld or not? It was upheld and it cut the whole claim short. So let's get into it. So Stan, who are some of the parties that are involved in this?
Yeah, so there was the plaintiff. Her name was Sandra Bernier. She also had two children that were claimants as well. So, pursuant to the Family Law Act, we may have touched on that in the past, but basically, anybody who's been involved in an accident, family members of theirs can join the claim because they've suffered a corresponding loss of care, guidance, and companionship and other damages. So, we have Miss Bernier and her children as plaintiffs. The defendants in the action were the City of Ottawa, an entity called Grand Fondo Ottawa, which is an event organizer for a cycling race. And there was also another entity called Nylene Canada. Basically, the parties are the injured person, and the defendants were the organizers of a race, a cycling race. So, why don't you take us through the next stages of the facts here, Hamish?
Yeah, so it's a cycling event, and Miss Bonnier is injured in the event, and it's not really disputed. It doesn't appear to be disputed. She's injured. The extent of it doesn't necessarily come up in the decision itself, but it seems to be acknowledged that she suffered injuries, and she's suing the event organizer uh, for essentially failing to plan and organize a solid event and warn of hazards along this cycling route. Now, she was a volunteer. Um,
That's
she
right. She
she was
was, I guess, like a race. What's the term that they use here?
like
Race
steward.
ambassador,
Yeah,
steward.
ambassador, steward.
Yeah, not a participant in the sense that her time in this cycling race mattered. She was there as a volunteer to ensure that everybody else knew where they were going and things like that.
Right. And um, so, in contrast, there are other people who are paying participants in this event. She's an ride ambassador. She's done it on a number of occasions. I think it's like at least once, maybe twice before. Um, and the path of this race takes them to an intersection of Loggers Way. And so there's a railroad track there, and we looked it up on Google Maps on Street View. And when you take a look at this, you can understand what would have happened.
Yeah,
It's essentially it's a rural area. There's a railway crossing. There's no lights or barriers or anything like that, and it's almost like an where the Loggers Way intersects the railway. It's almost like an X intersection, so it's not like a plus intersection. You're not coming up to the railway line at 90 degrees. You're coming up at it at a more acute angle than that. So um, it seems that as she's traversing this railway line, whatever happened, her tire gets stuck in the railway track. I could understand how this could happen looking at it. And she fell and she suffers injuries, and she's saying, hey, this should have been warned about. The event wasn't well organized to take us through this path, and not warn participants because this is kind of a hot spot of injuries. Um, that's her claim, and she's also claiming it to the city of Ottawa for um, there's claims related to essentially maintenance of the area and the surface of the area and stuff like that. So that's the basis of her claim. Now let's get into what happened beforehand.
yeah. So
And
the defendants, in responding to the claim, well, they took their waiver and they waved their waiver around, if you'll pardon the pun, and basically said, no, Miss Bernier has signed away her right to sue us as a result of executing this waiver. The waiver was sent to her a few weeks beforehand. It looks like it was executed about a week before the race took place, I think 6 days beforehand, signed online and emailed back. And it's indicated to be a release and waiver of liability, an assumption of risk and indemnity agreement. We're not going to read through the whole waiver. It can be found online in the decision if anybody cares to read it, but it specifically outlined that it would protect the defendants from specific claims arising in negligence, and more specifically, those potential injuries caused by terrain, facilities, temperature, weather, condition of athletes, lack of hydration, equipment, vehicular traffic, actions of other people, including but not limited to participants, volunteers, spectators, journalists, event officials, event monitors, and or producers of the event. So pretty broad, but also specific in the sense of it names a number of different people for whom there is protection granted by this waiver.
Right. And so the issues that come up in the summary judgment motion, there's a number of issues. It's one, is the waiver enforceable against the plaintiff given she's a volunteer? And that one, I mean, the answer is yes. And I don't think from the facts as reported in the decision, we don't have access to the affidavit evidence and the full evidentiary record, but from the decision, it seems pretty clear cut, right? It says explicitly that a volunteer waives their rights by signing this.
That's right. The waiver was specific and it did mention volunteers, I
Right.
believe on a number of occasions.
And then, does the waiver bar negligence claims? And I suppose it's negligence claims of the type alleged. Um, and Stan just read a portion of the release, and yeah, I mean it's broad, but it's also quite specific in the types of different uh, claims that are released. And I think the key part is, as you highlighted, even if arising from negligence, gross negligence, or negligent rescue. So yes, the waiver, she signed it as a volunteer. There's no dispute that she signed it. She read it. I think her evidence was she sort of read it diagonally, like she kind of just skimmed through it.
Right.
But if you go back to what the waiver said, it's pretty clear cut that it releases the parties of negligence.
That's right. And one of the things mentioned in the decision is, well, the fact that she skimmed it, the defendants don't know that. It was executed by
Hmm.
email. And if you sign it and send it back, they have no way of knowing how you read it. They can only assume that because you've executed it, you have read it.
Right. And in terms of the timeliness, that's something that comes up too. If someone, gun to your head, signed this waiver, you have no time to read it.
Race
Like,
starts in 30 seconds.
yeah. Um, that was not this case. It had been sent in advance. It was about a week before when it's not disputed that like a week before she read it, she signed it. It's not that she had a time crunch in particular that would have impacted her ability to read through it and sign it and in principle know what she's signing. No language barrier involved, no evidence of unconscionability or a policy issue with, oh, it would be unjust from a policy perspective to allow this contract to continue to exist and it to mean what it says. Um, Beyond that, there was a question of it being electronic. It didn't really seem to go anywhere in this case. I mean, yeah, she got it by email, but she signed it, and the conclusion was, on enforceability, yeah, the waiver was enforceable.
That's right. One of the positions that Miss Bernier took was, well, it was emailed to me. There was no explanation. I didn't really know what I was signing. And Her Honor, hearing the case, did not agree with that. Had said, you had signed it. We have to assume that you had read and understood it. If you didn't believe that you would be bound by it, well, then let people know. She had signed it the previous year. It had been signed 6 days in advance. There were a number of factors there.
Hmm. And I think the fact that she'd done the event before, I think that was also kind of an important factor. Like, as far as signing the release, she likely, I don't know if it's clear in the decision if she had signed a release in previous years,
I
but
think so. Yeah, I've got it here. Uh, at paragraph 60, Ms. Bernier had signed the same waiver the previous year prior to the same event held in 2017.
mhm.
So that's definitely a factor.
And then, there's often a discussion in these cases about just beyond even a waiver, but the basis is, are you assuming the risk of the activity on voluntary assumption of risk? And in this case, that's where it came up again that uh, she assumed the physical risk of injury and she was experienced. She'd done this before. She understood what cycling hazards were. And so she was, with knowledge, understanding the physical risks that she was releasing, and by signing and then participating in the event, with the waiver being enforceable, she was also assuming the legal risks, which means even if what I'm saying is not just a claim about physical injury, but I'm also saying my physical injury arose from your poor planning, this waiver uses sufficiently precise language. In this case, given the fact that she did read it, she did sign it, she'd had it for a week. There was no real time pressure, and the type of injury she had was the type of injury that you might have when you're cycling. Essentially, she fell off and got hurt.
Right. It's the kind of negligence that is contemplated by a waiver like that. Is that, a fairly foreseeable type of cycling injury occurred in this case. What I took away from this decision is if it's a well drafted waiver, if it's particular to the event that's taking place, if it's sufficiently clear which parties are being released, if it indicates the kind of negligence or the kind of dangers that are being waived, it's going to be upheld. If it's a very general type of waiver that is not specific to the event, does not enumerate the parties who are being released by the waiver, it would have a chance that it might not be upheld. So, a classic lawyer answer, you've heard it before from us, you'll hear it again from us. It depends on the situation that you're in as to whether or not the waiver will be upheld. It will depend on the quality of the waiver that was drafted. It will depend on the types of injuries that you've sustained. We can go through, I'm sure, and a number of different hypothetical scenarios where some form of misfortune befalls Miss Bernier that is not contemplated by the waiver that she signed. But in this case, we only have the facts as they occurred, and it seems as though it's a standard type of claim that would be captured by a waiver that she signed.
Yeah, and I think it's interesting to point out that on this case, with these facts and these factors, the waiver's upheld. Now, if you go through this case and if you just say, okay, hypothetically, let's say we tweak this fact or we tweak this other fact, then the conclusion just would be different or could be different at least. And so, I raised at the beginning, injuries are they're referred to. It doesn't seem contested that she had injuries, but we can do a hypothetical where someone had the most grievous injuries. And I suppose the question is, would that play a role in the decision making, knowing that judges are human? It could do.
It might. I think it, for me, would depend most upon the mechanism of injury and how that injury happened.
Yeah, and we, when we looked through this on Google Maps, we were thinking, well, I mean, it is a railway crossing. What would happen if a train actually came through this event and struck and hit her as she was crossing the train tracks? Like, would that type of injury be the type of thing that she's released vis-a-vis the event organizers? And
I have to think yes. I mean, you don't think that by signing up in this event that it would be scheduled at a time when trains are crossing that intersection.
right,
It's not a, as far as I can tell, it's not a commuter rail line. It's not a frequently traveled rail line. And had that type of thing happened, you would have expected them to have run it by CPCN, whoever runs the rails there, to make sure that there's no traffic coming through. And if it is, you reschedule the time of the event.
right. So if the event organizers failed to put in that call and just, it was on the to-do list, but they didn't quite get to it, and then the event proceeded and Miss Bernier was hit by a train and killed, then I'm not sure this waiver would be enforceable in the same way as it was in this case. Uh, Another thing that is just well, I'd say it's my opinion. It's also just one of the things in terms of how waiver cases can be more tricky than they seem at first glance. The two things that jumped out to me was in this decision, it focuses quite strictly on the words of the waiver and the legal meaning of those words. Now, there are other cases, a lot of them in the context is ski lift tickets, which put a lot more emphasis on the format of the waiver. And so in those cases, there's more emphasis placed on, are important terms bolded? Are they underlined? Are they highlighted? What's the title of the waiver? Uh, do you have to initial next to certain portions of it? Is it a big text wall of legalese?
Right, 78 pages or something.
Right.
Yeah.
So
Online waivers or things like that.
yeah, so that's one of the things that didn't particularly come up in this case. And we're all we're speculating. We have the decision, we know what the decision says, but we don't know what the actual evidence presented as part of this motion was. But for whatever reason, in this case, it turned more on the actual legal language versus the format of the waiver. And then the other kind of thing that I didn't see come up in this is the Occupiers Liability Act. And so the Occupiers Liability Act is essentially an act that talks about if you come onto someone's property or property that they're
In
in
control of.
control of, what steps you must take if you want to restrict the basic premise that essentially if you come onto property I'm in control of, then I'm responsible for things that happen on this property under my control, and the steps that an occupier has to take if they're alerting someone to the fact that, hey, we're restricting what we're saying we have to do in terms of steps to take care of you by presenting you with this waiver. So the occupiers liability cases, this just isn't one of those, but it's another complexity where, for example, if you're hosting someone at an event, especially in your club facility, the type of waiver you need in that situation doesn't necessarily look exactly like the type of waiver you need in a situation where you're putting on an event and you have volunteers coming and it's not in property it's kind of on public property essentially.
Yeah, for sure. So it's different in every situation. If you're a business owner, if your, trade is in hosting or organizing these types of events, make sure you have a good waiver.
Yep.
Consult a lawyer, get them to draft it for you. If you are engaging in these kinds of behaviors, we do encourage you to read that waiver beforehand to really understand what you might be waiving by way of your rights to sue in the event that something happens. And be careful.
Yeah, exactly. I mean, we've all read these waivers, and I think now, sometimes you see it and you know it when you see it, you're like, that's a good waiver. That seems pretty airtight. And you read other ones and you're like, I don't know. I can see some gaps in that.
Yeah. Maybe it wasn't drafted with sufficient care and attention.
Yeah. Well, with that, we will wave goodbye. Where can you find our team, Stan?
You can find us online at nelliganlaw.ca.
And I've been deficient in my LinkedIn posting recently, but I'll still drop my handle. You can find me on LinkedIn at linkedin.com/in/hmillsmcEwen. And Stan, where are you at?
Same place, linkedin.com/in/Stanford Cummings. I have been just as deficient, maybe more so. I think it went hand in glove with the pause that we took on this podcast recording. So maybe I'll go back and see if there's legions of adoring fans.
Yeah, and another way our adoring fans can contact us is, of course, by email at civilbanter@nelliganlaw.ca. And that's a wrap.
Right on.